The first case on the docket for Tuesday, March 29th, 2022 is appeal number 121503, State of Kansas versus Michael Glen Mulleneaux, Geary County, briefs both sides.
Council, would you please come to the lectern and enter your appearances? Chairs are a problem this morning.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Mr. Mulleneaux. And I don't know if you'd like me to ask to reserve time now or when I
Either
begin.
way is fine. I'll make
May
a
I
note.
please have 2 minutes for rebuttal?
2 minutes is granted.
Please the court, Tony Cruz, Assistant Geary County Attorney representing the state of Kansas, ready for argument.
Done. Whenever you're settled and ready, you may begin your argument.
Hey, may it please the court, again, Patrick Dunn, here today on behalf of Mr. Mulleneaux. At the outset, my wife is a teacher in the Blue Valley District, a middle school Spanish teacher, and just asks none of the students or their parents hold anything I say against her. So the first thing we need to recognize here is this is a simple case. June of 2018, Mr. Mulleneaux was arrested on a traffic violation, and during a search incident to arrest, the officer found a marijuana pipe in his pocket. Based on the residue in that pipe, the state charged Mr. Mulleneaux with felony possession of marijuana and also with the possession of the paraphernalia, misdemeanor possession of paraphernalia. He immediately files a discovery request. It's actually an agreement of the state's making 2 days after his arrest. So things move along right before trial. It's the week before trial is scheduled. Counsel goes to look for the KBI lab report, which purportedly finds THC in the pipe, and it's nowhere to be found. In the past, the state has said, well, you need to come physically look at the file. So counsel goes, looks at the file. It's not there. Following day, files a motion to dismiss. And the next business day is the Monday of trial.
Can I ask just a procedural or kind of a question regarding the report in question here? There were 2 preliminary hearings in this case, wasn't there?
That's correct.
And in both preliminary hearings, the state had the report and introduced it as evidence. Is that correct?
That's correct.
And at the time that exhibit was introduced into evidence at both preliminary hearings, did defense counsel have access to it and see it and look at it and an opportunity to cross-examine the witness who provided the report?
Yes, and as Ms. Cabrera, the trial counsel below said, at that point, she's not looking to thoroughly.
No, I understand,
but
there was access to the report, at least at the preliminary hearings in this case.
for moments.
I understand. I know how all that works. It wasn't like a mystery that
Sure.
it was a phantom report or anything like that. It was physically there at some point.
Sure, and I would point out that Ms. Cabrera did want to cross-examine on some other things, and the magistrate refused to let her and narrowed her cross-examination. So this wasn't a situation where she could just run amok and ask whatever she wanted. She had all the time in the world. So I'm not sure. The other important aspect, as you brought up the preliminary hearings, is what wasn't admitted, the pipe. So we don't know. Defense counsel's never had a chance to see the pipe, to know what this residue really was, how much was there. And as we know, and I'll talk about later, knowledge is an essential element of possession. So one might think they have a pipe and not know that they have possession of THC in there, and that's a very valid defense in the state of Kansas. So with that, I want to brief.
One other point for clarification is the Court of Appeals commented that they saw no connection between the two preliminary and the issue before the court. But it seems there may be a connection because as I understand it, there was a problem with production of a different report, the journal entry at the preliminary hearing. Am I accurate in that?
Correct.
So the state was missing a document at that point that hadn't been produced for the defense?
Correct.
Accurate
And
recitation.
defense counsel, I believe, and the wording of this in the transcript is a little unclear to me. And I initially interpreted it as the state said, if we don't have it in our file, we don't have it. You've got everything we've got. And that wasn't the case. And I wasn't sure in reading that if that was to the KBI lab report or just the journal entry or both or one or the other. So I just wanted to clarify, I'm not completely sure upon rereading it in preparation for today of that.
Counsel, can I just ask a procedural question? I'm sorry. And when the document was admitted at the preliminary hearing, did the court reporter keep a copy of the document? Was it withdrawn by the state and kept by the state?
I believe it was withdrawn by the state. Okay. Ready for issue one? All right. And I don't want to spend a lot of time on this, but procedurally, I think the Court of Appeals has fundamentally misinterpreted what's gone on in this case. The discovery sanction in this case was exclusion of the lab report and any KBI testimony regarding the contents of that report. That wasn't appealed. The notice of appeal was strictly limited to whether or not the district court erred in dismissing the case with prejudice. That was a separate motion. The initial motion was about the exclusion, and there was no revision to the district court's decision. That was the question of whether it was dismissed with or without prejudice had to do with basically would the initial decision ruling, the initial sanction, be enforceable. So that's not before the court. The decision of whether or not there was a discovery violation, that's settled. It's not the subject to appeal. So that is the main thing I wanted to point out in issue one. Had the state wanted to appeal that, they could have filed an interlocutory appeal under 223603. They didn't. This is an appeal from a dismissal under 223602B1.
So to put that in a technical term, would your argument be that it is the law of the case that the court is excluded?
Yes, and in the court's language, it is deemed waived and abandoned because it was not raised below and
I
preserved.
understand that part. Well, I'm need to understand a little better why you characterize isn't the district court's decision to dismiss with prejudice also considered as a sanction against the state? Because kind of characterize that as a sanction to exclude the report. And I understand we've got a bucket that's exclusion of the lab report. They didn't appeal that. The other bucket is the dismissal with prejudice. But don't we consider whether the district court abused its discretion in dismissing with prejudice with the idea that that's part of the sanction for the failure to discover? Because I understood your argument to be if we don't dismiss with prejudice, they're just going to do it again. Some other, they're not.
They're going to do it. They're going to do it in this
They're
case.
going to do it in this case.
They said that's what their plan was.
Right, but there's no deterrent in effect without the dismissal with prejudice. To me, that seems like
It's not the deterrent I'm talking about.
okay. Go ahead.
I'm talking about there is no exclusion. The ruling is there is exclusion. Now, it has to be enforced somehow. Now, either we go ahead and the trial goes forward. And again, fundamental problem I think the state perhaps didn't understand what it was allowed to do is you can try a possession case on circumstantial evidence. There's absolutely no requirement. All cases can be tried on circumstantial evidence. There is no statutory case law requirement, anything that says you have to have a KBI lab report. Sure, it makes your case easier, but that's not required. The state somehow seemed to think it had to have this. Now, not the case. So exclusion was the decision. So if you allow the court, if you allow the state to have its motion to dismiss, and that was who raised it. It was the state said, okay, I understand your ruling. I move to dismiss the case. If you allow them to do that, then there's no ruling at all. It's meaningless.
Is there another alternative that would have accomplished the same thing? Short of dismissal with prejudice?
I can't think of one.
Well, why wouldn't the court just say your motion to dismiss is denied?
Could have done that.
Well, that's the alternative, right?
Oh, yeah, I guess that is. I hadn't thought about that. Sure.
And so why should the state be penalized because the district court didn't do what it should have done from your perspective? Which
Because it
is
was the state's request to
But this-
dismiss the case.
not to dismiss with prejudice, though.
At that point, once they had raised the issue, they didn't argue, the state never retracted its motion to dismiss. If the state wanted to proceed, they could have said, okay, we withdraw that.
Well, but was that?
I don't see why
motion-
this is pushed on defense counsel. They were blameless in this.
But let me ask a clarifying question. My understanding is the state's motion to dismiss was to dismiss without prejudice.
That was correct.
And so there was an adverse ruling against the state, even though the issue was presented to the court in the state's motion. The court did exactly the opposite of what the state was asking.
I don't think they did the opposite. They took a twist on it, is what I think. And again, and I think we also need to,
And that's the ruling as I understood your argument, that's the only ruling that is before us on appeal.
that is the only ruling before you. And I think the other thing we need to remember is the standard review on dismissing with prejudice,
And I guess the
which is
question-
abuse of discretion.
Right.
And you may not have done that. And Judge Atchison pointedly notes he wouldn't have done that,
Why isn't
but
it,
that's a standard of review.
why isn't it a mistake of law, though? I mean, what legal grounds exist for a district court to dismiss this case with prejudice?
There are no legal grounds that he can't. She couldn't. It was a she, I'm sorry, Courtney Bohm. There is absolutely nothing. The statute that we're talking about, and this court has recently said, we care about statutes. It is a valid discovery sanction to exclude evidence. We all can agree upon that. It is plain as day in the statute. That is one of the statutorily authorized remedies, and that is the statutorily authorized remedy the district court granted. Now, after that's granted, the question of dismissal with prejudice, that's a totally different question. That's not a discovery question anymore. We're past discovery now. Now we're at the point of, okay, we have dismissal before us. How are we going to do it? Now, the state says, I want to dismiss the case without prejudice. Defense counsel says, no, if you're going to do that, you're going to get an end run around it, dismiss it with prejudice. Sure, there was a third alternative apparently, but that doesn't mean it's an abuse of discretion that the district court should not be able to enforce its legitimate statutorily authorized ruling in a different way. It doesn't have to do it only one way.
But isn't it a different question? Ask whether the court has some obligation to think about whether there might be a way to accomplish the sanction in a less nuclear way without
No.
missing it with prejudice.
I think, again, you're conflating the sanctions. They're not the same sanction.
No, I'm talking about does the court have an obligation to consider various options?
I think when we're in the situation as a district court judge, you do what's in front of you. You don't always consider the third alternative. This was the first time I'd considered Justice Stiegel's proposal. I hadn't thought about it. The parties clearly didn't think about it below, or this, I mean, ultimately, this is the state's problem here. The
So
state did not ask. It did not propose this alternative, and it should, the fact that this court now seems to sound like it wants to darn the state's socks and do the state's job for it. I mean, one of the big problems I have with the Court of Appeals ruling in this case also, which we haven't talked about, is that the Court of Appeals shifted the burden of everything to the defense here. It said, well, there's no proof of prejudice. Well, that's not how it works. The appellant has the burden of proving these things.
I'm
If the
talking
state
about
wanted
the
these
court.
findings.
I'm
Sure.
talking about the court, whether the court has an independent obligation to consider whether there's a less ultimate sanction that would accomplish the same thing. Not defense counsel, not even the state, but the court.
I don't think the court does based on what it's in front of them. I would also point out that even if you consider this the nuclear option, it's really, if you look at those Jones factors, which we don't think really come into play because this was a statutorily authorized sanction. But if you look at those Jones factors, there are other reasons you consider. And in this case, it's clear this isn't the first time this has happened. The state's response as to why it happened was, well, we don't know. Mistakes happen, things fall through the cracks. And I understand that. But it is certainly a valid consideration of the district court not to reward negligence. And in this case, this is a residue case. This is not a person felony. This is not, no one was hurt in this. This is residue about the lowest possible harm to the state, residue of marijuana, the lowest possible harm to the state I could possibly think of. And if you are going to have a case where you dismiss it, that is the least harmful, if you're going to have this sort of balancing thought, which under the old law, there is supposed to be some balancing on who's at fault, yada, yada. But if there is any sort of balancing, this is the sort of case where you say, this is a good case. It's not going to be a major harm to everyone, that we actually can sanction the state in a manner whereby dismissal is okay. Dismissing a residue case rather than a first-degree premeditated murder case, I think we all agree the residue case is the case you want to dismiss.
Counsel, can I just, if I understand your position correctly, I just want to ask a couple follow-up questions to make sure. When you dismiss with prejudice, you have to do so to further the interest of justice. Is that correct?
Sure.
And here, what the furtherance of justice, I guess, I view it as insulating the discovery sanction. In other words, you're dismissing with prejudice, or the district court is, because you don't want the state to circumvent that discovery ruling. Would you agree with that?
I think you're also, that's part of it. The other part, again, is what I pointed out as far as stopping a repeating problem.
Okay,
And
a deterrent then.
Yeah,
essentially.
it has both an enforcement and a deterrent effect. It's both.
And when we review that on appeal, as I understand it, your argument is that that on review, a court is not required to embrace only the least restrictive means of accomplishing the ultimate goal of furthering the interests of justice.
Correct.
It's a balancing test, in other words.
And again, we're also looking, remember, this is not a legal test here. This is an abuse of discretion standard.
Correct. Okay, thank you.
And I was informed earlier that etiquette is that I should point out that my time is run. Again, if I could say one last point, and that's to reiterate, if the state wanted findings regarding prejudice, regarding wrongdoing, these sorts of things, the place to do it was in the district court. Not now. It's not for an appellate court to make its own findings on these. There were no explicit findings. And when there's no explicit findings and when there's no request for those findings below, then this court has to presume that the district court made findings in support of its ruling. So I guess we inadvertently, roundabout way, covered everything, unless the state brings something up, and otherwise I would at the case and wait for rebuttal.
Thank you, Mr. Dunn. Mr. Cruz?
May it please the court, Tony Cruz on behalf of the state of Kansas. As Mr. Dunn pointed out, the court did dismiss this matter with prejudice, which the record clearly shows that this was an incident that somehow the maybe a lab report was not provided to defense counsel, and we found out about it. If the timeline was basically the defendant was arraigned late April, the matter was set for jury trial on June 10th. Didn't find out about the defense counsel not having the KBL lab report until the evening of June 7th, which would have been Friday.
I interrupt. I'm sorry, just for this. Can you, move the microphone? I'm not sure.
Sorry.
No, it's a problem with our microphones. We're working on that issue, but I appreciate it. Thank you.
Excuse me. So we don't find out about, or the state does not find out about that missing discovery until 5 o'clock, a little bit after 5 o'clock on Friday with the jury trial on Monday. Once we discovered that, we provided it to defense counsel by email that over the weekend. Had we been apprised of that prior to that date, we would have provided it. It wasn't a situation where we were trying to hide anything. We have an open file policy, just because there are times when reports come in. Our policy is whatever comes in goes out to defense counsel, that we don't try to hide anything. We don't try to keep anything separate. And this was just one of those situations. And oddly enough, we had 2 preliminary hearings, so I'm still not sure why that KBL lab report was not provided to defense counsel. But once we became aware of it, we turned it over.
I understand why you're defensive about this, but why do we have jurisdiction to even talk about it?
Because the court dismissed this with prejudice. And that to me is an extreme sanction for an oversight. Even the Court of Appeals, when I miss a deadline on a first time brief, they'll tell me, you know, that you miss a deadline, have your briefs submitted by this time period. In this particular case, once we became aware of the fact that they didn't have the lab report, this was an extreme sanction. I mean, the motion limiting.
You agree we don't have jurisdiction to consider the court's ruling on excluding the lab report from evidence?
I would agree with that because the only issue that the Court of Appeals took up was the dismissal with prejudice. So I think
That's all you appeal. That's in your
Right,
notice of appeal and
right.
in your docket statement. So
Right.
it wasn't even that the Court of Appeals limited you. You picked your fight. And so that's what you've got. And so you're saying that missing with prejudice, the court didn't consider the inadvertence of the state in creating this problem.
correct. And it goes beyond just, and I hear it all the time because I'm the main drug prosecutor for Erie County. Well, it's only a marijuana case. It's only this case. But the problem is, if this court allows this type of sanction for this type of violation, that opens up the Pandora's box for every other.
But how is
case.
it fair to the defendant? You know, as I remember, the defendant was from Topeka. The Topeka comes to Gary County, ready for trial. It's the morning of trial. The defendant's there, ready to go. And now you're showing up wanting to dismiss the case so that you can refile and correct your problem. How's that fair to the defendant?
Had we known about the lab report not being turned over, we would have turned it over sooner. So defense counsel knew that we didn't have it in our file because they even looked at it.
So
And didn't notify
the
us.
court needs to be unfair to somebody, and you're choosing to say the court abused its discretion by being unfair to you rather than unfair to the defendant.
I don't see it being unfair to the defendant because again, there's an old adage, and I believe it's out of his court, that a defendant is entitled to a fair trial, not a perfect one. And I think in this case, again, had the state been apprised of this issue prior to the Friday evening beforehand, we would have turned it over. And even over the weekend that we turned it
The
over.
Court of Appeals, Mr. Dunn is saying the Court of Appeals did, which is to put that burden on Mr. Mulleneaux. Didn't you have an obligation to be sure that this defendant was given the report?
We do the best that we can, but again, sometimes things, and again, had it been in our file,
What does the discovery statute mean? When the defendant had filed a request for all discovery, does that mean the state does the best it can? Or does it mean it provides all of the evidence that is, that would fall under the discovery provision?
we provide all of the discovery as it comes in. And the discovery statute specifically even has a section that says that we have a continuing obligation to provide discovery. And again, if this was yeah, things happen. I don't take,
I don't think
things-
anybody's saying the
But-
state was
But again,
fictive or malicious, or there
Right.
was a bad faith involved here.
right. And again, had there been bad faith, had the defense filed a motion to compel, saying, look, we asked for it, we still don't have it, what's going on? And we refused to turn it over or didn't turn it over in a timely fashion, then I would agree. Dismissing this with prejudice would have been the proper sanction. But being advised that they don't have something the eve of trial and then providing it and then still being sanctioned and then being given the most extreme sanction, and that is having it dismissed with prejudice, that doesn't even
Bruce,
give the
let me-
opportunity to cure it.
Interrupt you very quickly. You keep referring to the dismissal as a sanction, but it's my understanding, and I think Mr. Dunn talked about this, that there's two, or even Justice Biles, there's two buckets here. There's the bucket of excluding the lab report, and that was the sanction, right? Excluding the lab report. And at that point, the trial would have gone on. But you, the state, filed a motion to dismiss at that point, right?
I made an oral motion. Yes,
Right,
ma'am.
a motion to dismiss. And then defendant comes back and says, a motion to dismiss without prejudice, so you can refile. And then defendant comes back and says, whoa, if you're going to, we oppose that motion to dismiss. But if you're going to grant it, you should grant it with prejudice, right?
Right.
So that's not really a sanction. That was a ruling based on, it didn't really have anything to do with, I mean, you could say it's related, but did it have anything to do with the issue that has not been appealed in an interlocutory appeal, which could have been done, correct?
That I'm not aware of. I'm not really sure
Okay.
that the state could have appealed a motion in limine.
Like a suppression motion, right?
Correct.
So the state
yeah.
had a lot of different avenues it could have pursued, but the avenue it decided to pursue was, we want to dismiss this case and refile it. So what the district court had in front of it was dismiss as the state requests without prejudice, or and on the other hand, dismiss with prejudice. And then would you agree that we look at the court's decision based on that for an abuse of discretion?
You said discretion based on and those, the two sanctions, and I call them two sanctions because that's what I believe they are. And I apologize, my pen blew up this morning, so I've got blue instead of my hands. The court, in the state's opinion, the court basically had issued two sanctions. One was the motion in limine. The other one was the dismissal with prejudice, because if you look at the record,
How can that be a sanction when you are the one that requested?
because I requested it to be dismissed without prejudice. The court dismissed it with prejudice. The state's concern is that there was no legal basis to dismiss it with prejudice. Because when they filed the motion the motion in limine, the court had various options. The court could have continued that matter. The court could have.
But that wasn't what was before the court. You moved to dismiss. So you're saying the court, even though it's presented with a motion and a response, then the court is required and has the burden to say, well, what else can I do that they're not asking for?
I think the court has the inherent power, and I think that they have the duty.
Power, but do they have the duty
I do. I think
when
that
we're
they
looking
do.
at abuse of discretion?
I think that they do, because the cases I cited, there were discovery sanctions where defense or the court said, okay, fine, we'll not get into that topic till tomorrow.
But aren't you
Defense, but got
conflating the
tomorrow.
sanctions, for the discovery violation? Here, the motion, it seems to me, when when we're looking at abuse of discretion, I mean, I don't really see where the error of law is, because the court is saying, am I going to allow the state to refile this whole thing? So just like none of this happened? I mean, it's really abusive process, right? So, I mean, you could say the district court did it to avoid abusive process.
I don't see where it's an abusive process if, and I know that there was, the defense counsel said that the state could have still proceeded to trial,
Right.
not on a residue case. Because again, normally, and I understand that cases can be tried on circumstantial evidence, but you've got, in those types of cases, you've got the ability to have other types of evidence. For example, homicides, you have a dead body. The question is not whether or not somebody was dead or not. In this particular case, you have residue. The officers can't testify that there was marijuana residue in the pipe because all they can say is the pipe smelled like marijuana.
Right.
So again, to prove it to a jury
What's wrong
beyond
with
a
that?
reasonable doubt, I'm sorry, I don't know if any prosecutor that's ever tried a residue case based on circumstantial evidence where you don't have the lab
Mr.
report.
Cruz, also one other question. Do you think when we're, because you didn't ask for more particularized findings when the district court did this, is it possible for us to take into account that this was a pretty serious case? Because even though it's a misdemeanor, this is a very low misdemeanor residue. This was his third hit, right? So turned it into a felony, correct?
This was a felony, yes.
Right. And so what would the jail time be on that?
That would depend on his criminal history, but
Prison.
if he's got no criminal history, you're talking 10 months. If he's an A felon, you're talking 42 months.
Right. So this isn't some diversion case or some probation case. This is a felony. And actually, when the state filed its first information, it said there were 2 prior convictions for possession. So it's a felony charge on the residue. They had the first preliminary hearing, and then the defendant filed a motion to dismiss for lack of probable cause because, again, the state inadvertently, I don't believe there was any malice, but the state inadvertently did not have a journal entry on one of the priors. So that was dismissed, and then there had to be another arraignment, a second information, a second preliminary hearing. Do you think that the judge took that into account, that this was the second mistake that the state had made to cause a lot more? This is a lot of extra hearings and paperwork and, and this is what turned it in. This was a felony.
Yeah. To back up just a bit, just because it's a felony possession of marijuana doesn't make it presumptive prison. This was a presumptive probation case.
Okay.
Okay. As far as the first preliminary hearing, we had documents. Unfortunately, the documents that we had requested didn't have everything that the court
Didn't have the
wanted.
journal entry.
No, we had journal entries. Just, it was a matter of, if I can recall correctly.
Well, you agree. We don't need to go into the
Yeah.
specifics, but you do agree that it was an inadvertent mistake on behalf of this state that happened in July of, I guess it happened in January of 2019, which pushed everything back a couple months, right?
Right, but we did provide the journal entries, except when, and it got bound over.
Right, because you
And then-
refiled.
Right, and
So
then.
that, so you already refiled once.
Well, I didn't refile, I filed amended complaints, so there wasn't anything that was pre-filed. But the district court did not agree with the magistrate court to find there was probable cause, alleging that the journal entries that we had provided were insufficient to prove that he had 2 priors. And that's.
I
what
show
we
the
had to do.
motion to dismiss count 1 was granted on March 18th, 2019. So if it was dismissed, you couldn't have filed an amendment. You had to.
That the felony charge, because we hadn't proven that. It was a felony.
Exactly. Right. So I think we agree on that. Thank you.
Getting back to Justice Stiegel's question, because this was a residue case and you needed that lab report in order to make your case, had the court simply said your motion to dismiss without prejudice was denied, it has the same impact on the state as the court's ruling, which was dismissal with prejudice, right?
I'm sorry.
You weren't going to be able to go to trial and get a
Oh,
conviction
No,
with,
no.
based on the discovery sanction. So regardless of whether the court had said just denied your motion, not said anything else, just no. You were in the same place because the charge was going to be dismissed with prejudice or there'd been acquittal, right? You didn't have a case without that lab report.
Right.
Okay.
One quick clarifying question. At the beginning of your argument, you were talking about the timeline with regard to the turning over of the report.
Mhm.
It sounded to me like you were suggesting that perhaps the defense was essentially playing possum. Is that right? In other words, I wanted to clarify, did I hear you correctly that from the state's perspective, the defense knew that it didn't have the report and it waited up until eve of trial to notify the state?
That's what it seemed like.
How much time passed between the file inspection and the notification?
The final, okay, the arraignment was in late April. The jury trial was June 10th. They inspected it June 6th, which would have been a Thursday. And then they didn't file the motion in limine until Friday. And I want to say it was after 5 o'clock, but if it wasn't after 5, it was like right at 5 o'clock.
So 24 hours later.
Yes, ma'am. And unfortunately, because of the weekend, had no real way to contact the court to see if we had, on the second preliminary hearing, had not withdrawn the exhibit or accidentally
So
given it to
just,
somebody else.
I guess, final question, that short period of time doesn't strike me as playing possum, as I put it. Would you agree with that?
I would say that to wait until, had defense counsel notified us that day, hey, where's the lab report? We would have tracked it down that day and provided that day, because I was able to do that over the weekend. And I understand that it was a short setting because generally we don't have jury trials where you have an arraignment in late April and then a jury trial in June. Normally.
Wouldn't the
they go out
defense have
over months.
filed their same motion? I mean, I just don't see how that would come out any different. Whether it happened on Thursday or Friday, I don't see the difference.
Had it been known on Thursday, we would have, again, been able to do some research about why it hadn't been turned over. But again, to wait until Friday afternoon, that gave us like no time, so.
Thank you,
Thank you.
Mr. Cruz. And you reserve 2 minutes.
As I always say, this is at my own peril. The only thing I really want to mention again is that if the state contends this is some sort of possum situation, they could have gotten that finding below. That's the place to have it. That seems like a factual finding to me. Again, this is not a Pandora's box situation where if you do it in a residue case, it can happen in any other case, because this is an abuse of discretion, and the courts have said we decide these things on a case-by-case basis. Case-by-case means it doesn't control every single case. You look at all the different factors that came into play.
Counsel, looking at our decision in State v. Bolin, it suggests to me that a district court does not have the legal authority to dismiss with prejudice unless there's actual prejudice to the defendant. Would you agree with that?
There's an implication of that. It's also on a case by case because
guess
you can have, if say the prosecutor is thumbing his nose at the state, which I think is the Clovis case, then that outweighs the prejudice in and of itself. We contend, we pointed out some prejudice.
Well,
Counsel below said this is the most important piece of evidence. This is a residue case.
Right.
I gave you some reasons, but the bottom line is we have to presume, that's the law. If there's no objection or a clarification of findings, we presume the district court made that finding.
I guess I just want to cut to the chase and say, why isn't this a case where the state wins the battle, but you're going to win the war? I mean, there is no prejudice, right? Because this case was not going to go forward. The state was not going to get a conviction. period.
Well, I don't know what would have happened. That's why things go to
Isn't
trial.
that
That's
the-
why people settle in civil cases.
I understand,
You
but
never know what's going to
what
happen.
I'm trying to
Any number of
think
factors
about
go into
is
play.
what would the right way to have approached this been? And if it's true that our case law says, look, there has to be actual prejudice to the defendant. And this seemed like a quick trigger on dismiss with prejudice.
I don't
Why
think
doesn't the state, as I put it earlier, win the battle but lose the war here?
again, I'm not seeing it as a quick trigger because again, this was, the state below said, oh, this defense counsel always comes in and asks for dismissal. But that's not what happened here. That isn't what happened.
But you
Defense
agree-
counsel went the lower sanction exclusion. The state asked for
Right,
dismissal.
But you agree.
And it's a case of be careful what you wish for.
You agree that the district court has to have a legal basis to enter an order dismissing with prejudice. Can't
Yeah.
just do it because they woke up in a bad mood.
Sure.
And want to go to
I
trial.
completely agree there, and they have a
That
totally
the-
legitimate
The
reason
legal
in that
ba-
we're
the legal
enforcing our earlier
basis
rule.
here is to enforce my discovery sanction.
Correct.
That's the legal basis.
Yes.
And we have case law that says what you have to do when that's the case.
So
And you would agree then that we're just at just an old fashioned abuse of discretion
that's,
review of that.
yeah, and in my line of work, normally I don't advocate for the abuse of discretion standard, but this is one of those situations where perhaps it works in my favor.
Are you conceding that there isn't prejudice from the standpoint of the defendant having to pack up and
Oh, we absolutely believe you're correct. there.
come in from Topeka to Geary County and, take a day off of work or whatever, especially after the other delay in proceedings and other things that happen going forward? It seems like to say there's no prejudice ignores certain realities.
I don't see how we can say there's no prejudice. Again, this is a simple residue case. This is 299 days, I believe, if I counted correctly, after arrest here. There's no reason a simple residue case cannot be tried within 299. No motion to suppress, nothing. The only motions arose in the last month based upon what happened. We had a motion in limine on prior convictions. That's a pretty standard thing. We don't want you to bring in 6455 stuff. It's the only motion in this case until the discovery issue, which was the second motion. There's two motions, simple case. No reason this should have been continued. And sure, I don't see how that's not prejudicial to keep saying, you're going to have to come back for something that wasn't your fault at all, something you didn't ask for. Sure, I think there's other forms of prejudice. And then again, I'd fall back on the final thing. If the state wanted findings regarding prejudice, they should have asked for them at the trial court level. Thank you. And we'd ask this court to reverse the Court of Appeals and affirm the district court.
Thank you to both counsel for your arguments this morning. The court will now take this matter under advisement.